careful adding your kid to the title of your property, especially if they're married. My buddy's mom is about to get her home ripped out of her hands. Hear me out. So my buddy Anthony has a brother named Michael. Well, the mom added Michael on title after her husband died years ago. Michael's married. This guy goes out, cheats on his wife, and so she's scorned. So in the divorce, she wants half the house. So now they have to force sell the house just to pay her off. But here's the problem. They just can't do it on themselves. Because the divorce is dragging out, she puts a lien on the property and no one can do anything. And this chick is so mad that she's putting her lawyer bills as liens on the property. So it's eating up all the equity. So what the mom should have done is pretty much, if you want to give it to Michael, created a living trust and add him as the beneficiary.
I do like the solution of putting the asset in a revocable living trust, although that's actually not the only way, nor is it the most affordable way. If the mother's in the state of California, there actually is something called a transfer on death deed, and all that does is it allows the mother to list a beneficiary to the property in the same way that you could list a beneficiary to a checking account at the bank. The fact that the transfer doesn't happen until the death of the mother means that there won't be a capital gains landmine that's planted when it is time for the son to sell it. If you're in California, the best place to find out more about this deed, along with getting an actual sample of the deed, is at the Sacramento Law Library website. That website will also kind of walk you through how I fill out the deed and also what the pros and cons are of using a transfer on death deed. The mom had the volition to add someone else's title, which means that they might have the equivalent volition to do a transfer on death deed. To expect someone to do a trust where the undertaking is so large, it may never get done at all.